Hi, everyone, and welcome back to our VWV Employment Law podcast. My name is Jess. I'm a legal director and a knowledge lawyer in the employment team here at VWV. So, this episode is part of our Workplace Compass series. Some of you might have listened to some of our past episodes already, and this is a collection of resources for employers who are just looking for a bit of clarity and direction as our employment law landscape undergoes one of the most significant periods of change that we've seen in recent years. So if you haven't already, do like and subscribe to our podcast so that you don't miss any future episodes.
And I'm Nick, a partner in the employment team. Thanks for joining us. Today we're going to be looking at the latest developments following the House of Lords votes on 17th of November, what the Lords agreed, what happens next, and what this means for the timetable towards royal assent and implementation.
Yeah, absolutely. So as lots of you will know by now, the Lords debated the Commons position on the 17th of November, so as at the time of recording yesterday afternoon, and that debate included several key areas of the bill, including 0 hours contracts, a statutory definition of seasonal work, the concept of day one unfair dismissal rights, political funds and industrial action thresholds. And much to the frustration, I'm sure, of the government, in every one of those cases, the Lords reinstated their earlier amendments. So listeners may be aware that the bill has been toing and froing for quite some time now between the Commons and the Lords. And the headline point is that the Lords' position hasn't shifted. So those core points of difference between the two houses remain in play.
Yeah, and what really stood out this time was how consistent the voting patterns were. So none of the divisions were close. That tells us that peers from across the House continue to have strong reservations about certain elements of the bill, particularly where the practical impact on employers is likely to be greatest.
I think we can see that borne out in the substance of the amendments themselves. So let's look at some of those in more detail. So on 0 hours contracts, for example, the position of the Lords is that they are continuing to favour a process where, in terms of how the right to be offered a guaranteed hours offer will work, that the Lords are proposing that employers should write to workers at the end of each reference period to explain the right and to give them the option of declining an offer, rather than having offers issued automatically. And so that there's a sort of opt-out mechanism that the Lords is really insisting on, which the government so far doesn't want to give way on, because their concern is that will water down the guaranteed hours offer framework too much. Also on 0 hours, the Lords reinstated a statutory definition of seasonal work. So again, they're saying that the government's version of the bill doesn't go far enough to protect employers of seasonal workers, and that it's going to be too restrictive for them. So they are wanting an amendment that is designed to essentially ensure that future regulations reflect the seasonality and fluctuating demand in certain sectors.
Yeah, and of course, the most fundamental difference between the two houses remains on unfair dismissal. So the Commons support day one protection, while the Lords prefer retaining a 6-month qualifying period. Those are two very different models of protection, which have wider implications for recruitment practices and probationary arrangements and the amount of secondary legislation that's going to be required to support the system.
That's right. And in addition to all that, if that wasn't enough, the Lords have also maintained their position on their union-related elements. So they want to require new members to make an active choice about political fund contributions. And really interestingly, actually, and significantly, they want to keep the current 50% turnout threshold for industrial action ballots too.
Yeah, so overall, there's a very clear and consistent set of decisions that are coming from the Lords on the areas that they've repeatedly returned to the Commons throughout the bill's passage.
All of these amendments now have to go back to the Commons again for further consideration before the bill can get royal assent.
Okay, so before we move on to the timetable, it's worth touching briefly on what is likely to happen next. The bill now goes back to the Commons for further consideration, and the process could take more than one round to resolve. Every time the Lords have made changes, the bill must be considered by the Commons, so the back and forth inevitably creates some delay.
Yeah, that's right. And I think the level of resistance in the Lords, that is significant as well. So the amendments that they have reinstated go to some of the really core sort of headline features of the bill, and they've been passed, as you've said, Nick, with really clear majorities. So naturally, this is all just increasing the pressure on the government because at the end of the day, these key manifesto commitments. So from the government's perspective, there is an expectation that, that they ultimately will be delivered.
Yeah, definitely. And one question now is whether the government decides to release more detail on the light touch dismissal framework that it has referred to for statutory probation periods. That has been a particular point of concern in the Lords, and further detail might help to narrow the gap between the two houses.
That could certainly help, I think, in terms of just getting the unfair dismissal changes over the line, or at least bringing the two houses closer together. And the other thing, I think, is whether there might be scope for compromise in the way some of the provisions are implemented. So even if the high level commitments ultimately remain the same, is there some detail around secondary legislation that might just help achieve the agreement that the government's looking for? But I think whilst this is all speculation currently, we do have to say, and currently the government's position is that it does intend to just press on with the bill, and it's not said anything about its implementation timetable slipping either.
Which brings us on to timing, and parliamentary time is becoming an important factor. Jess, do you have any thoughts in relation to that?
Yeah, so Parliament is scheduled to go on recess over Christmas from the 18th of December to the beginning of January. So if the bill is not passed within the next few weeks, we're not going to get royal assent this side of 2026.
Okay. So before we finish, let's touch briefly on what employers can be doing now. Even though the detail of the bill is still being finalised, this is a good moment to start preparing for the introduction of the bill.
Yeah, absolutely. And, when we talk about preparation, that doesn't have to mean committing to changes prematurely if you're worried about the government changing its position on some of the key issues. Lots of employers are starting with a simple sort of stock take. So a review of workforce models, contracts and HR processes, just to understand where changes are most likely to have an impact and start anticipating those.
Yeah, and for those employers that are wanting more structure, we're supporting clients in two main ways. The first is our Employment Rights Bill implementation audit. That is a short, practical review of key documents and processes to identify where future changes may be needed.
Yeah, that's right, Nick. And the second thing that's worth mentioning is our training options. So, our listeners will know that the bill is going to shift expectations around really key things like recruitment and probation in the context of day one unfair dismissal rights, 0 hours working, and how maybe your casual staff are managed. So supporting managers and HR teams to understand those changes very early on can really help make implementation smoother.
Yeah, and the key message is that there are sensible steps that employers can take now without needing the final wording of the legislation, and early preparation will make implementation much easier once the detail lands with us.
Absolutely. And of course, for anyone listening today, if you would find an initial conversation helpful, then we're also very happy to discuss what the reforms might mean for your organisation.
Thanks, Jess. And that brings us to the end of this episode. Thank you for listening.
Yeah, thanks, Nick. And to everyone listening, if you found this helpful, please do like and subscribe. We're going to continue to provide updates as the bill continues its progression through Parliament right the way up to implementation.
Yeah, and if you'd like more insights like this, you can explore our full Workplace Compass playlist or head to our Employment Rights Hub for articles, resources, and all the latest updates. It's all available on our website.
Thanks again for joining us. We'll be back soon with the next instalment.